502-267-2422, 502-267-2422. Workers' comp, question, Social Security, disability. Maybe you've been involved with an accident, you're not sure what to do. Karl Truman is here, as he is every Tuesday. I talked about him right before the break. The big ruling out by the Kentucky Supreme Court, and it wasn't even close, 7-0. It goes back to that tragic Calm Air crash in Lexington back in 2006. But a spouse can now sue, according to the Kentucky Supreme Court, if you lose someone in a plane crash or in a related situation. If you lose your husband, you can now sue for that lack of companionship, that lack of having that loved one there over this grieving process you're going through. Your reaction, this is huge.
It is huge. I mean, the legal term is what's called loss of consortium, loss of spousal love, support, affection. And it's been a big defect in the law for a long time now, and finally that has been fixed. It came out of, as you pointed out, the Calm Air crash where people lost their spouse in the crash. And the Kentucky Supreme Court has decided that, yes, a spouse can sue for loss of consortium, and it's a big deal.
Could they, 7-0, is that it for the opponents? I don't think that, excuse my law ignorance, can they take it to the Supreme Court or U.S. Court of Appeals?
No, this is a state question. It's not a federal question, so it would not be something for the United States Supreme Court. This is strictly state law.
And it seems to me if there's some, and I don't know the proper words here, but if there's negligence or if there's just wanton conduct that causes someone to lose their loved one, you should be able to sue. Now, how is it in Indiana? Do they have that?
Well, and it's the law not for loss of consortium, but in Indiana, and this is another one of the huge problems in the law has been in Indiana until just a couple of years ago. The law was tweaked somewhat, but if you were an adult and you had no dependents, meaning you weren't married and you didn't have any kids, and someone kills you, whether it's from a medical mistake or you get run over by a truck, your life is worth zero. The statute did change a few years ago. There's some of the work from organizations that I'm involved in, some trial organizations, that if you have a parent or a child, they may not be dependent, but they can still make a claim on your behalf, but it's capped at $300,000. So, if you're a 40-year-old wage earner, you have a long life ahead of you, or even younger. You could be 25, but if you're living out on your own, basically, the law has capped the value of your life at $300,000. So basically, what that means is it's cheaper to kill someone than to hurt them.
Well, what I don't understand is you see some of these tobacco verdicts down by a jury where someone who was smoking 30 years ago and the cigarette companies knew that it was bad for you. They get $26.8 million or $5.8 million or $6.2 million or whatever the case may be. But when you have a clear case, whether it's a hospital, a plane crash, and you're not overstating it. It is a clear case, $300,000, less than $1 million. Something's just not. It's not balancing there.
I had a call just recently. This is from a case in Indiana where it was an adult. I think he was like 40 years old, and he was killed by how he was killed really wasn't important, but his sister was calling on his behalf, a grown sister. Mm-hmm. His parents were already deceased. He had no children, was not married. In Indiana, his life is worth zero. Mm. Just until recently, which this is talking about the wrongful death context, again in Indiana, and this has been a long-standing debate in both Indiana and Kentucky, is if an unborn fetus, if you have a child, if a woman is carrying a child, and whether it's an automobile crash or something like that, whatever that causes the death of that unborn child, what is the value of that? Because until recently, the state of Indiana has put a greater value on the loss of unborn pigs than they did of the loss of an unborn child. There's been some modification recently on that, but in the past, if a child was unborn, the law put that value of that child at zero.
Well, Karl practices in both Indiana and Kentucky, and he has a blog, he has a website, trumanlaw.com, 1-800-ACCIDENT. If you need information, you're not sure where to go, you could call Karl, and his staff over there, and they'll help you out. Wanda from St. Matthews sent an email, and it sort of talks about what we did 2 weeks ago. I don't know if she was needing clarity or not, but Wanda writes, my sister had a procedure at a Louisville hospital and developed a staph infection. She seems okay now, but is still on medication and will be for some time. Her care was great, and she has recovered from a minor surgery, but she got an infection. Should the hospital pay for the ongoing treatment? You talked about this a week or two ago, and the answer is now staph infections are business as usual, I guess.
Basically, staph, from a medical malpractice context, staph infections have become so common, and it shouldn't be tolerated, but they become so common in hospitals. Basically, the doctors now say, well, that's an expected complication of a surgery procedure. So in most situations, getting an infection at the hospital would not be considered medical negligence.
Stuart from Fairdale writes, Karl Truman here on the Legal Line on WBKI TV, Louisville Live this morning. Stuart, appreciate your email from Fairdale. If you're in a car accident like a fender bender and the damage is under $2,000, is it worth it reporting it to your insurance company? I was in an accident a few weeks ago. No one was hurt. We exchanged information. Both of us admitted we were wrong. He braked at the last minute and I didn't stop quick enough. My deductible is $1,500. Instead of making a claim, it seems better to dig in for the remainder of the damages. So sort of a gray area, not a gray area, but a fine line there. What's your thought on that one?
That is a tough spot for on a case-by-case basis. And so if you have this caller or this email had a $1,500 deductible, $2,000 worth of damages, no injuries, is it probably worth it? In the long run, probably not. I mean, it depends. If you had prior claims, is this a first claim? If there, had there been multiple claims? So it's a case-by-case basis. But I mean, if it's a few $100s difference, it may be worth it. And it's a shame that we spend so much for insurance coverage, but we're all so afraid to use it. It's like insurance is the only product we purchase that we never want to use it as intended.
Well, I think a lot of people fear they're going to lose it if they use it one time. But if you have a question, again, if you've been involved in an accident and you slip or fall or anything like that, medical, workers' comp, give Karl Truman a call, 1-800-ACCIDENT and TrumanLaw.com. Karl, thanks for being with us again, and we'll see you next Tuesday.
All right.
Thanks so much. Still ahead here, our Young Brands Foundation Dare to